My name is Jane Scharf, and today I bring you the Truth in Action Share Club's Saturday Hero of the Day, Adam Skelly. His courage deserved a stronger constitutional fight. During Ontario's COVID-19 lockdowns, Etobicoke restaurant owner Adam Skelly reopened his small restaurant, becoming a national symbol of courage. He took a visible stand for the right to work and operate a lawful business. Public donations reached $350,000, and this case had the potential to become a defining constitutional challenge to provincial authority. Early in the matter, I participated briefly on the legal team. Afterward, Chris Weisdorf assumed a leading role in directing the legal strategy, advancing a defense based on Section 15 of the Charter, claiming discrimination against small businesses. I objected immediately, for clear legal reasons. The Supreme Court of Canada has made clear that Section 15 does not create unlimited or implied equality categories. Equality rights are tied to recognized grounds grounded in personal characteristics, not economic or commercial classifications. Even assuming implied categories were possible, a small business could not qualify. It is not a personal characteristic. Section 15 protects individuals, not commercial status. The facts did not support the claim. There was no favoritism. Major chains were subject to the same takeout-only restrictions. The real issue was arbitrariness. Why were certain industries essential while others, like restaurants and gyms, were closed? The stronger issue was jurisdiction. Lockdown orders imposed prohibitions backed by fines and enforcement to protect public safety. Measures of this nature resemble criminal law in purpose and effect. Under Section 91(27) of the Constitution Act, 1867, criminal law falls exclusively within federal jurisdiction. If a province exercises powers that are criminal in substance, the issue is not reasonableness, but whether the province had constitutional authority at all. Absence of jurisdiction invalidates the law. The public impression was that Toronto police were occupying the restaurant. It later emerged that those present were off-duty police officers hired as private security. This distinction matters legally. Administrative enforcement carried out through privately retained officers raises different constitutional questions than ordinary policing. Toronto Public Health, under Dr. Eileen de Villa, issued a notice stating public health was occupying the restaurant and would rely on the Trespass to Property Act. There was no clear statutory authority for administrative occupation of a business without a court order. The Charter framework includes Section 1, which allows governments to justify rights limitations as reasonable. Throughout COVID litigation, courts accepted public health justification under Section 1. By relying primarily on Charter arguments, the case entered a framework where courts were already permitting rights restrictions. A jurisdictional challenge would have asked a fundamentally different question. Did the province possess constitutional authority to impose these measures at all? In the Alberta Press Reference of 1938, the Supreme Court struck down provincial legislation interfering with freedom of the press. The court did not balance interests. It held the legislation invalid because it exceeded provincial jurisdiction and interfered with freedoms essential to democratic governance. Civil liberties fundamental to democratic participation are not provincial subjects. They fall within federal constitutional authority, and provinces cannot regulate or suppress them directly or indirectly. Laws enacted without jurisdiction are void from inception. Adam Skelly demonstrated genuine courage. Resistance appeared futile, given visible enforcement, administrative occupation, and unsuccessful litigation. History shows victory depends on both courage and precise constitutional arguments, leading to constitutional victories. Where is our Canadian Bill of Rights, which protects civil liberties, which is a federal matter? When a historic constitutional opportunity arises, how much depends not only on bravery, but on who is trusted to guide the legal path forward?